To the courts we go, where the Supreme Court of Appeal, the SCA, has ruled in favor of a consumer, Aletta Van Niekerk, in a landmark case against FirstRand Bank. Van Niekerk had purchased a second-hand Ford Ranger vehicle on credit, only to discover serious latent defects, including a faulty gearbox and oil cooler, days after delivery. She sought to cancel the credit agreement and reclaim the money paid, relying on her common law rights and the Consumer Protection Act. The bank refused, taking the matter to the High Court, which initially ruled against her. On appeal, the Supreme Court of Appeal overturned that decision, confirming her right to cancel the credit agreement and recover 170,000 R23.23, plus interest and costs. The ruling clarifies how the National Credit Act interacts with the Consumer Protection Act, particularly concerning defective goods purchased on credit. It also sets a precedent for consumers facing similar issues with banks or credit providers. Let's break it all down with consumer journalist Wendy Knowler, who joins us now for a discussion on the ruling, its implications, and what it means for everyday consumers. Wendy, good afternoon. Thank you for making the time to have this conversation with me. It is quite fascinating, this case, bringing as it does various areas of the law, which are quite complex for common lay people such as ourselves to navigate. Tell me, what are the key takeaways for you from this case?
Okay. The important step in that process of that particular vehicle, which was a Ford Ranger, was that when there were gearbox issues, they took it back to the dealer where they had bought it in Klaksdorp, and the gearbox was replaced. But the breakdown happened again soon afterwards, and in evidence it emerged from a mechanic, which was not challenged by the bank, that the replacement gearbox was for a completely different vehicle. So you have quite a serious case here where the court found that there were latent defects with the vehicle, that it had most likely been in an accident, and that the repair, had been incompetent. And I think it's important to highlight that, because when we talk about, we have now the right to involve the banks with regard to defective vehicles, we can't have a situation where someone sort of finds a scuff on the upholstery and says, right, I'm cancelling the deal, and banks, do your thing. We're talking about cases where the vehicle was found to have major defects which weren't disclosed by the dealership, and the crux of it is that the High Court essentially said that she should have, Aletta Van Niekerk, she should have gone through the normal consumer protection channels, the ombudsman, a provincial consumer court, then through to the commission and the consumer tribunal. And the full bench of the Supreme Court of Appeal said, absolutely not. This was a common law right to cancel the deal. And actually, it was the bank who took this to the High Court. So she had to, argue her case in court. What turned this case was that the banks, actually they always do, like to separate themselves when a car develops a defect and the owner doesn't want it anymore and wants a cancellation, because they say, well, we're just the financer, we the credit provider. You take your problems up with the dealer. And the Supreme Court of Appeal said absolutely not, and pointed to various clauses in that West Bank agreement where the bank says, we remain the title holder of the vehicle until it's fully paid off. And they retain what we used to call in the old days the logbook, the registration certificate. Yes. And they said, you clearly wear two hats. So you are the credit provider, but you are also the supplier of the vehicle, and that's the new precedent now. And so the banks can't, as the Consumer Goods and Services Ombudsman Lisa Brati said afterwards, the banks can't now refuse to take any liability for the car. Obviously, this applies to only finance cars, which is about 50% of all used cars in this country.
Yeah, in fact, say a bit more about that distinction between the bank saying we are merely the financiers of your purchase of this vehicle, and your real remedy and perhaps your gripe should be with the supplier being the owner of the vehicle that sold it to you. And in each case, does that then raise different areas of law, one being the Consumer Protection Act, or in the alternative being the National Credit Act? What clarity does it bring, this judgment, in terms of when do you resort to remedies in the Consumer Protection Act and when do you resort to remedies in the National Credit Act?
Okay, so I think when it comes to a situation when you want to cancel the whole contract because the defects were so glaring, an attempt to repair them was unsuccessful, many people would just be happy with the car being repaired to their satisfaction when the bank could stay out of the picture. But when it comes to a point where, the consumer has reached the end of their road with this vehicle and they want the deal to be cancelled with good reason, that's good reason, then the bank can't say, well, we were the supplier, we aren't the owner of the vehicle, because they actually are. And their own legal documents state that. And they retain the car's papers. You cannot sell your car, if you haven't paid it off because you don't have the papers to do so. So that's the big thing. But I think the real upshot of this ruling of last week is going to be, as Trudy Brookman, the attorney who represented Aletta Van Niekerk, said, now that we know that we need to return a defective car to the bank, the banks have all the incentive in the world to do quality checks, which will keep the worst lemons off our roads. And for me, that's going to mean that, right now, if you buy a car and it's financed, they want you to provide proof that it's insured before it's driven off the floor, right? And now they're going to, for their own protection, because suddenly they've inherited this massive risk for all these cars they're financing, right? Should they be defective? Mm-hmm. So I'm pretty sure, are going to insist, which they should have done years ago, that the dealership provides proof of an independent mechanical testing of the car, proof of mileage, which is the big one, because fraudulently turning back mileage is a major thing in the used car industry in this country. Providing all that proof that the car actually doesn't, as in this case of the Bakkie, have latent defects, wasn't in an accident, a serious accident previously, etc., etc. They're going to want to see all that and interrogate all that proof before they finance a car. And that, I think, is the biggest consequence of the Supreme Court of Appeal ruling.
Lastly, Wendy, just on that point, will consumers be better off with that added layer and that added motivation on the part of the banks to ensure that the vehicles they finance are in a good state, that almost added responsibility? Will we be better off, or will it mean extra hoops to jump through before the financing of a vehicle?
I think we'll be better off. I've been saying for years that consumers should do these checks themselves. A number of service providers provide them. They're relatively inexpensive. But what tends to happen is they want the car, they feel rushed. There might be somebody else that wants it. It's supposedly a good second-hand car, and so they miss that step. So now, if the banks rather, take that responsibility away from the buyer and say, we're going to take it for you, because if this car has had 100,000 kilometers shaved off the odometer, if it was in a major accident that wasn't disclosed to you, we want to know about that, because otherwise it's going to be our risk. We're going to have to cancel the deal can you imagine the logistical nightmare for the banks if that happens en masse? So I think, yes, it's absolutely a good thing for consumers.
All right, let's leave it there. Thank you for your time this afternoon. Consumer journalist, consumer ninja, Wendy Knowler, weighing in on that judgment coming through from the Supreme Court of Appeal.